9 o'clock. Here's Mr. Hale. So let him sign in and we will get started with the formalities. Okay, it's 9 o'clock on Monday, October 26th. Mills County Commissioners Court is in session. If y'all would stand and join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Commissioner Williams, would you lead us in a prayer?
Dear Heavenly Father, thank you for this rain you have bestowed upon Mills County and the state of Texas. Thank you for everything that you have given us. Father, be with us today as we do the business of Mills County. God and direct us in all our actions. In Jesus' name we pray. Amen.
Thank you. Okay, for the record, all four commissioners and the county judge are present in the courtroom. We have a quorum. Since we have a mixed in-person and media participation, let me just go down who's where.
I don't think you hit record on the biz system.
Let me find it. Thank you.
How you're going?
Thanks. Okay, Mills County Commissioners Court of Monday, September 26th is in session. We have all four commissioners and the county judge present in the courtroom, which constitutes a quorum. For the benefit of people attending remotely, we also have present in the courtroom County Attorney Gerald Hale, County District Clerk Sonia Scott, and we have in the audience Dale Parton. We have attending via YouTube. I'm not YouTube. Wait a minute. I just saw Brian Witt join us, I think. Yeah. Attending on the internet, we have Jackie Brooks from my office, who is proctoring the technology for this session. We have the Mills County Sheriff's Department. The picture's too small to see, but I'm guessing it's probably Tina Allensworth and Chris Green. We have County Treasurer Trina Busby. We have the County Veterans Service Officer Craig Wright. And I see Michael Pritchard, who I recognize from being with Swift Current Energy. So that being a roll call, and then we have people on YouTube that, of course, we don't even know about. So with that, the first action on the agenda is review and act on the minutes of two meetings, October 12th and October 15th. Everybody's had a chance to look at these, and these are Ms. Scott's first official minutes.
I'm going to be approving the presented, Judge.
I got a quick little change on the special meeting.
Okay.
It's the second to last paragraph. Commissioner Williams provides the swimming routes can reopen if the weight limit is 8,000 pounds is enforced. Commissioner Williams stated if it is reopened, the county will install cameras. The county has already installed cameras. TxDOT's opinion is that the county can't guarantee weight limit. Do not open the bridge, and so that's what we did. So, because we couldn't guarantee it. Just want to make sure that was clear.
I will add that to that.
Commissioner Guerin, would you care to amend your motion?
Yes, sir. Correction to Commissioner Williams implied.
Okay, we have a motion to approve the minutes of October 12th and October 15th as amended. Is there a second?
Okay.
There's a second from Commissioner Williams. Okay, any further discussion? All in favor say aye. Aye. Any opposed? The minutes are approved. Audience with individuals. Ms. Scott, has anybody brought you a sign-in sheet to speak?
Yep.
Okay, we have no one signed up to speak. Consider an act on accounts payable. These were distributed electronically Friday. Let me find mine. I had a couple of questions. What is, Ms. Busby, Omnibase Services of Texas? It's in non-departmental expense.
Just a minute, let me look.
Okay.
Oh, that's for, that's the court, federal, failure to appear fees, that they're quarterly fees that are collected in the JP's office.
Okay.
I have one question, Judge, if you don't mind.
No, go ahead.
It's for Jason Precinct 4. Water gap, it says that on County Road 508, $2,750. What is that?
What we did when we replaced that cement, little water crossing on 508, we had to, take down the fence on, the west side of the road. And, to do that, to make all those repairs necessarily, we hired, what's his name?
SP Construction.
Yeah, Peters, to help us redo that, and then he rebuilt that, and a portion of it was our cost, but the major portion was, the landowner's cost. And some of his work coming up on that. I asked, and I did not get the bill before the end of the year. So it was under that.
I wondered if, nobody get to it or what happened so long. What did you
Yeah.
do?
Anyway, so, but it's been with, I don't know. I asked a bunch to get that, and he brought it. He didn't even bring it to me. He brought it to Joe Brooks and gave it to Joe Brooks, and Joe Brooks brought it to me, and then I took it to Trinity. So, yeah.
That's all I had.
I don't have anything else.
Nothing.
Okay,
Motion to approve accounts payable.
we have a motion to approve accounts payable from Commissioner Wright. Is there a second? Okay, second, Commissioner Guerin. Any discussion? All in favor say aye. Aye. Any opposed? We have approved the accounts payable. See, the next one, this is just listed as a discussion. We've carried it forward for a couple of meetings. Discussion, possible action on the burn ban. I don't know about you guys. I get periodic calls, most frequently have been either commercial contractors that have cleared and want to burn piles, or in one case, somebody in precinct 4 who has a brush pile in the middle of the black from the last fire he was trying to burn. It looks like we're in for 3 days of rainy weather, but then it's followed by dry again and possible high winds. So just wanted to throw it out there if anybody has an impression one way or the other on whether or not we should do a temporary lift. We have a 90-day statutory requirement on our burn ban that we have to reinstate it, or it lifts on its own, and that 90 days is going to come up November 14th. So we'll have another meeting or two before we have to deal with that.
We get enough moisture, I'd love to see us lift it for a day.
I was just going to say the same thing. Maybe till Thursday, or whatever. So
If it rains today and Tuesday and Wednesday.
Yeah.
And we have a meeting, special meeting Thursday.
We
too,
do.
So we could lift it now. And
if we need, think we can extend it.
Well, I mean, all we need to do a temporary lift is myself and one commissioner, and it sounds like there's at least 2 or 3 and one of the fire chiefs. So if someone would volunteer to track down one of the fire chiefs and see if anybody can go along with, say, Monday, Tuesday, Wednesday, and then we can revisit on Thursday.
I think we need to do away with Judge Thursday, we like our rain warning for Thursday.
Yeah, that's why I was suggesting that maybe it ends Wednesday. We're still have high range chances then.
I'll call I'll call it a fire marshal.
Okay. Yeah. Okay.
Fire chief.
I'll let everybody know, but if we get a fire chief concurrence, we will do that through Wednesday and put it out there on the website. But since that's going to be done under existing authorities, there's no action required. We'll move on to the next item, which is a discussion of the Mills County EMS station. When we had the EMS report last week, the EMS director raised the issue that within a year or so, he thought we should have a new EMS station and cited that the current station was, the bays were too small for the new ambulances they were buying, and then went on with a reference to mechanical problems with the building. Commissioner Wright now went over there and took a look at it. You want
I
say-
tell you what, I was impressed with the upkeep of the old building. It is old. Of course, they're having problems in drainage, what they've told us. They're having problems, like the judge said, parking the new ambulance. It's longer and wider than what they've had in the past. Also, they've had some leakage problem from the roof line. But I think the majority of the problem is that they've just outgrown it. There were, 4 people that are making a presentation to us, or 5, and there's just not any room. You can't turn around in the building, you're walking over each other. So it's probably looking at times to make a change for us. And that was one of the questions I had for the court. How does it work with us having half the building belonging to us, or they intended us to help pay for a new one, Judge? That's the only question I have.
That was not really said, but I think the county probably should own the building, because ambulances companies come and go. I mean, we had one, we have this one, San Saba had one, they changed it. No matter what, we're going to have an ambulance station here, and rather than have to say, okay, we don't like this company anymore, but we're hostage because they have the station, we probably should own it and rent it to whoever we're using. That being said, they own and it might have been Bade. I wasn't on the court at the time. Some of you guys might have been, to get them to come in and take over our business, our ambulance business. We gave them that station, equipment, inventory, all that. Might have been a credit or something on the bill, but we gave it to them and retained
F ownership.
No, not ownership. I don't believe. We'll ask the county attorney, but if they sell it, we get either half the proceeds or half the profit.
Yes.
They, my understanding, own it lock, stock, and barrel. We just have, if they sell it, we get half.
get half.
That's the way it read to me.
Right. I was
Miss-
talking to a few people, and they said that they looked at building a new, Hamilton looked at building a new station behind the clinic. And they kind of find out it wasn't big enough property for what they wanted, or what their needs were. It's not that big right behind the building.
Let me ask the county attorney, do you have any recollection or historical knowledge of that real estate transaction?
I have a vague recollection of that, but I would have to look at the documentation to know for sure, and I have not.
Okay. Yeah, I mean,
This is sounding familiar, what these guys are saying, but I couldn't verify that.
No, it is. I don't remember, again, Gerald, see if your mind will work, didn't work. Didn't we keep a little piece of property behind the law enforcement?
Yes, we do. That's really not, in fact, I shredded
Yeah.
what it amounted to. Well, that fence line goes down. It's just a temporary or imaginary fence line, but we own all that behind it. And there's plenty of room.
That's what I'm thinking, yeah. I mean, that'd be a good,
Yes, it would be. We keep it, we try to dead now. We keep it, they ask us to try to keep it mowed down. Johnson grass gets up so bad, and right before I took the brush cutter back to him Thursday, we went down and we shredded it all, but that's the reason we did it. In case
I mean, they're basically wanting a barn,
yes.
and then they need living quarters, a barn with living quarters.
So it could be a metal building with spray and insulation.
Be a good place one, Jason.
Just thinking that, the only
They
thing
own the
that
property.
Yeah, and we could, I'm not saying, but we could do a lot with that parts property.
Well, let's, and that way, if the county owned it, we own the land, so there's no cost there. And if it ends up not being an ambulance station, it could be expansion for any number of other offices, from courts to law enforcement. Okay, we'll keep looking at that. I'll look at that possibility. Talk to the ambulance company a little bit. I think we're talking something here that's at least one and maybe two budget cycles out in front of us. At the same time, we do have potential money if we do a pilot program on any of these wind things. So it may all fit together a couple of years in the future.
Well, looking at the situation over there too, is that I think that we asked a question also about room, and they're landlocked over there on that building site too. There's really not any place, and they have a portable building moved in, living quarters now behind the EMS station itself. And they said that also that they still have a lot of people that come up and knock on the doors and come in and get treatments and stuff. And I'd rather see the court invest in a building before we put money back over there in that building.
Yeah, and
Wayne Cassidy told me that the sewer runs uphill across his property, across that old building, and you can see it on top of the ground. It runs up against an alley up there. He goes, it goes uphill. They have a pump just to get their sewer up to the dump.
Yeah, we went out the back door.
Yeah,
the
looked
judge
at
and I
that.
did. You can see a pipe.
yeah, they told me that backed up again on Friday. But that the sewer system's been what it's been since they moved in, or probably since we operated it. So
I could quote Irving Wilson on that issue.
okay, well, that's given me some direction. I'll keep moving on that. Let's move on to number 7. Discussion, possible action, county appointments, Mills Central Appraisal District. We got a letter that's in your package. We have the county appointed 3 members to the Appraisal District Board. 2 of them are county appointees. The third one is some combination of historical lore and prior action, where when the Star School District was dissolved, the local community wanted to continue to have representation on the board. For some reason, the county was designated as the person to make the appointment rather than the school district, but with the understanding, albeit not really well documented, that it be a local community. So now where we are, that person that we appointed and Commissioner Williams, who filled the unexpired term of Gary Daniels, we have December 31 appointment limit coming up. These are 2-year appointments. So technically, this letter is telling us, hey, we got 2 people that will time out December 31st. They're asking us to designate somebody by December, I can't read the letter, I think 15th. So we have the time. I'm not here to spring anything on anybody. I just want to give the background, have y'all thinking about it. But then the letter, which was a little odd, had 2 things attached to it that aren't referenced in the letter. And I wanted the court to see these. They're minutes of prior appraisal district board meetings, I believe is the way I read them. One's from 87 and one's from 14. The one in 14 deals with the county appointing picking up the appointment following the consolidation of Star School District. Although I don't think it says the appointment has to be a resident of that community. The other one, the older one, the 1987 document, and find all the right pages. They point to say that only one of the county's representatives should live in the Goldthwaite School District. What?
Two
Two?
of the representatives.
Okay, yeah, I've shuffled pages somewhat. I'm having trouble finding page 2. So you've been present at some of these meetings, Commissioner Williams. You want anything you'd like to clarify?
So it was brought to the attention of the board. I'm not sure 100% who brought this to the attention of the board. But Jim Runyon made the motion to make the city of Mullen, the representative, instead of Mr. Mason, and take him off the board, who was a representative, our representative. Could not do that, not of a lack of a second, but he couldn't do it anyway because you have to do it in August. The statute says you can only do it in August. So then it come to the attention after research that it says that only 2 members of Goldthwaite can be appointed that live in Goldthwaite ISD. Well, here's the thing. When that was done, Star ISD was in effect. Well, Star is now part of Goldthwaite. So the next problem is if Mullen ever consolidates with Goldthwaite, let's just say that never happens, but if it did, you would have the Mullen one would be part of Goldthwaite ISD. So basically, the restructuring, the reorganization of the board needs to happen, and they did admit that in the last meeting. But right now, and I don't know, maybe Gerald looked at this or not, but they're basically wanting myself and Mr. Mason to remove ourselves from the committee,
From the board?
from the board. Or I heard Jim Runyon, and we have to remove somebody to get them outside of the Goldthwaite ISD school.
Mr. Hales looked at this, and he can speak for himself, but the Texas Tax Code gives the Appraisal District Board the authority to reorganize itself, but there's times that it has to do it, and notice requirements to entities and rights to object and so forth. I think the reorganization time, I believe, is in August with notices to the entities by September. So they've missed that window this year. Mr. Hale, would you?
Yeah, I
Speak
did,
for yourself.
I did do some research on that. The judge sent me some information, and I didn't bring it with me, but there's, as I understand it, there's 2 sections in the election code to deal with it, but the main section lays it all out, says the board shall consist of 5 members, and the composition of that board depends on the pro rata amount of the taxing amount of each taxing unit in the district. Whoever collects the most money in the district gets the most representatives, and prorated out among those 5 members. That's the basic structure of the statute. But then there's another section that says, but the appraisal district can change that composition or change the procedure for appointment of members upon notice to all of the taxing units and the failure of any taxing units to object to it. So basically, the appraisal district can restructure the board or restructure the procedure of appointing the board as long as they send the notice out to everybody that they're going to do that and nobody objects. There's another procedure in there that says taxing units have the authority to change the structure or procedure of the composition of the board, but on their own, but that has to be approved by 3/4 of the taxing units. So those are 2 ways that you can change the basic structure that says 5 members appointed depending on pro rata amount of taxes collected by those units. Now, I know that the appraisal district apparently has revised those procedures from time to time, and apparently that was done without any objection to any taxing units, I don't know. But they basically can do any restructuring or changing in procedures, provided they send this notice out that you're talking about timely and nobody objects to it. If just one taxing unit objects to it, they can't do it. Can't change it. So that's my understanding of the law.
I guess that's the reason that the Mills County had two representatives, because they paid more in taxing, and I guess they collected more for them, and also the Joy ISD, they had two representatives.
Of course, you gotta do the math. City of Mullen may not tax enough to
That's,
give them legally, to give them one, but you've only got 5 members.
But you can have, doesn't it say you can have up as many as 13?
Yeah. You
Yes.
can have more if the board changes procedures and nobody objects to it. That's exactly right.
Yeah, at one time, it's my understanding that Mills County was the dominant taxing entity. But that was before the big school bonds issued by Goldthwait and before the Star consolidation.
and I assume now Goldthwait ISD is the,
Yes, they charge and collect more taxes than the county does.
But if you look at it now too, of those 5 board members, or there's 7 board members now that are on there, 5 of them are from Goldthwait ISD. And so you see what I'm saying? That's where the,
Yeah.
because you only got Mullen and Star that are not in Goldthwait ISD.
And Pretty-
Not
and-
all those members are for Goldthwait.
And Pretty, Goldthwait, Star, and Pretty.
Yeah, I mean, Goldthwait Pretty.
Yeah.
but Gerald brought up the issue too, with, we had some other school districts in that's not represented on this board too, also.
I asked
Yes.
that question, Mike, because I thought the same thing you did, but they are represented in their counties, so they don't get a representation.
Yeah, you're talking about Lameda and Hamilton and Brooks Smith and
Yes, they're represented through their appraisal districts, not through ours.
Though the taxing dollar comes out of Mills County.
That's what, yes, that's the way I understood it. Yeah, because all 3 of those school districts bring in more money than Mullen, the city of Mullen does.
yeah, I looked, Mullen's tax take last year, I think, was just over $8,000.
So it's an issue. One, I would like to be reappointed. But J.C. Mason would love to stay on it because he wants to represent Star area. And I've had a dozen phone calls of people wanting us to keep our handshake deal to have representation from Star
But,
on that. But-
Basically, the eastern part of the county.
Yeah,
but basically that's based on the decision of the board of the appraisal district, without any objections from any entity, what they decide to do. Is that not correct?
on the check, you mean, well, that'd be on
On
the
who got
restructuring, that'd be on the restructuring of the board. That
Yes.
really
No,
comes
yeah,
from
the
Star.
entities appoint, but the
In December,
appraisal
we have to
district gets to set the framework.
Yes,
Yeah,
yes, that's based on the board.
so,
Don't we have to kind of wait for their decision, what they're wanting to do before they bring it to us?
Well,
We have to read,
we-
nominate.
we have, yeah, this, before December
December
15th.
correct?
They can't do this until fall, August, September time period, to do a reorganization under the tax code, July,
We make our
August.
recommendations on our appointments, and then the board can change it December the 15th if they decide to restructure the board.
The board can't until September. So that's the issue. We have to, we either reappoint or we lose 2 seats at the end of December. The statutory window for the board reorganization is July, August, Commissioner Williams said, with notice to the entities by September of next year. So we're going to have to take an action in the interim, and then they're going to have to do something, may do something late summer, early fall, and then it'll come back to us, the Commissioners Court, to accept it or reject it, and the school boards and everybody else.
So we can make our recommendation for our appointment,
Yeah,
correct?
that's my understanding.
And then the appraisal board has a right to restructure and change that appointment?
They have the right,
As long as an entity doesn't object to
as
it?
no entity objects. That's the way I read it. I believe that's the way Mr. Hale reads it.
So, yeah, it's,
So,
yeah.
The other option is we gotta find somebody that lives in Mullen or Pretty ISD to take mine or JC's place,
or Jim Runyon's.
or Jim Runnels.
Oh, the commissioner's court's
Yes.
what you're saying?
Yeah.
Okay.
So that's why I wanted to get this on here so we can be thinking about it, and maybe in November, we need to a workshop if we need to, or just a list of names and then decide what we want to do.
Does the court want to keep a member of the commissioner's court on the board? That's kind of a question too, that we, because you're trying to find somebody from Pretty. We're fixing to have an individual from Pretty that serves on this commissioner's court.
Right.
So,
I feel that it's a benefit. I really do. Feel it's a benefit. Like, I think every taxing entity, I mean, I don't know if the legals, I know the commissioners can be on the board. I know that it says that in statute, but I don't know like the school boards. But I think that I have a member from each school board on that appraisal board too. I don't know if that can happen, but it really helps to know where that entity's going.
who's serving from Pretty now?
Danny Cox.
Danny Cox.
Okay, then that
And he's up for,
kills that ideal of having somebody on the court serving, because he can't, personally, that'd be two people from Pretty.
But it doesn't say you can't have two
it doesn't
people
say
from
you
Pretty.
can't have two from Pretty, so
Okay.
it doesn't.
It
say
just
you
says they
have
can't
two
be from
all. They
Goldthwait.
You just can't have more than two from Gold. That's the,
Interesting deal, isn't it?
Yeah.
That kind of sounds like confusion, trying to hold the water.
Yes.
You get two from Pretty, you get
but the other side is what the judge said a while ago, is Goldthwait ISD is the large, and what Gerald was saying, is the largest taxing entity right now. So really their representation should be more. And so that's going to come up in this comment, because Goldthwait actually has, Mills County actually has the three, and Goldthwait on ISD on these two.
Well, I mean, and you're mixing apples and oranges, because you're at one level, it's who appoints them. And at the other level, it's where they live. So, I mean, the issue is the court's appointed three because that's the way it works. But all three of those now live in the Goldthwait School District, but they weren't appointed by the Goldthwait School District. They appointed two other people.
So, yeah.
And that's where you're finding yourself.
Yeah, that's what I'm saying. And if Mullen was to join and consolidate, then you've got even a bigger Goldthwait ISD.
Yeah, the board would all have to live in Pretty.
I mean, so you're probably gonna have to restructure, because who would have thought in '87 that was gonna happen? So
Yeah.
One of the ways to find out is kind of put out fillers, asking somebody.
Well, I mean, to me, this isn't just a place where you put volunteers. This board should be doing meaningful work, or is. I mean, there's policy and budgets that we pay for with little choice. I mean, we've seen the budget come here before. We have not approved it, but unless some percentage of the entities don't approve it, it just happens and we have to pay it.
Yes.
So we need somebody that won't view this as a honorary seat. It's a working position, and it all fits together, because this is where our revenue comes from. And it also, when we talk about subdivision policy, I mean, everything interrelates.
I think anybody that serves on these committees and boards and stuff, they're doing it because they want to have interest in our community. I think they do the best of their ability. So
well, I hope that's what everybody.
yes, that's what I look at it anyway. But hopefully that happens.
Well, we've had a number of people that have, through various commissioners, that have expressed interest on it. Ultimately, it's going to be a decision of the court, and one we're going to need to make before December 15th. And
Can you bring us a list of people, Judge, that has contacted you that'd be interested in serving, representing the county, that we can kind of discuss?
I can I've had little direct contact. It's come through other commissioners, but yes, we could do that, assuming everybody's willing to have their name talked about in public.
Right,
Yeah.
public, in the public.
Yeah.
Yeah, I'd like to see that, who's wanting to serve on it, that's.
Well, I don't know that any of them will want to. They've said they're willing to.
serve.
Yeah.
Okay, well, by stating that, that means that they're wanting to, be a member of the board.
Oh, I don't know. I think
So
it's a
you have
community obligation.
3, is that right? Yeah, we'll have 3 commissioners court before we have to have that done.
Yeah.
So yeah, we can bring it back.
Could we discuss things like that in executive session, Mr. Hale? The individuals to be appointed? I know we couldn't make the decision
On who you're going, on the person that you're going.
on the evaluation of different individuals.
Yeah, you probably could. I don't think you can discuss it in executive session on how you propose the makeup of the board, how many you're going to hear.
Right.
If you're dealing with personnel and who you're going to appoint, I think. so, executive session.
Okay.
That keeps everything out
Yes.
in the public.
Personnel
Yeah.
matter.
Okay.
We need to get somebody on there that represents the county's interests. Besides Jason, because we're spending $220,000 a year with. We don't have a team.
Okay. So everybody's up to speed on at least what the issues are there.
Got complicated.
Yeah.
Well, you just keep going down this agenda. It just keeps getting complicated. Discuss county subdivision ordinance. Since I think Commissioner Hall brought this up last time, county attorney sent around a draft copy of a subdivision ordinance he'd been working on. I sent around one I'd been working on. If you read them, you can tell it's just different. There's different ways to look at an elephant and try and describe it. And it doesn't make either of them right or wrong. It just, they come from different perspectives. My focus was on land use, roads, floods, fires, and the county attorney's focused on title, survey, real estate transfers. And the best answer is you start putting these things together, and then you try and resolve conflicts, if any, and there probably aren't any. But if anybody's got comments on either draft, if you send them in. I had a suggestion from, maybe like Commissioner Guerin speak to it. You talked to TAC.
Yes, I talked to Paul Sunday, fact, if you look on, if you're interested in this, look on county.org, tax website, look under legal, and look under subdivision regulations. There's 551 pages of subdivision regulations. Law suggested that we get, attorney that's real familiar with subdivision regulations that help structure this. Is it that in the long run, that'd be the best thing we could do, as far as getting the right one corrected. I read over all the judges and all the girls and judges, right? They need to be combined. But I really think we need somebody that's real familiar, does it all the time to help us get the right ones down. And all of them should have things we'd like to see added to it or whatever. I'd like to see some requirement for water. They say, I won't prove that there's water there. You know how much water it takes for the family of 4? Take 12,000 gallons a month.
Oh, I see the tree.
Yeah. And you take 10 houses, that's what I've got down water. I don't know exactly much water in this county, but it's to satisfy. And then they got the fire.
When you talk about that too issue, Jed, I don't know if y'all been out lately on County Road 410. We have a vineyard been placed, and there's gonna be another 80 acres. They don't,
Of what?
grapes, vineyard.
Irrigated?
Yes. And I know it takes a lot of groundwater to do that, but I don't know if we ever have the authority to stop someone doing agriculture stuff on private property. This court does.
We don't.
And we don't. And that's a big issue that we'll get into even with water. Because at one time, I know when we had a water board here, they wanted to one time discuss metering the wells in this county. And you know how that went over. It was a big issue here that they didn't want anybody, you know, they buying their own wells and drilling their own water, and the county telling them how to use it or how much they could use. They didn't go over very well. And it's a tough situation there.
But I mean, to me, the agricultural use is something different, that theoretically those are big boys. So the thing on platting I believe if somebody buys a platted lot, they have certain reasonable expectations that it's usable. And what you want to make sure and do on your plat requirements is disclose that just because this is platted doesn't mean there's garbage service. It doesn't mean there's sewer service. It doesn't mean there's water service, you know, because these things can get sold mail order. I mean, people advertising all over the state, you know, buy 5 acres in Mills County for $20,000, and that looks like a bargain for somebody.
It is
in Dallas.
those people in the city.
And they think, okay, it's a city, and they come out here ready to plug in and turn on and find out that there's another $20,000 required. And to me, the plat is one place to head that off. You either don't plat lots that are not usable, or you have enough disclosure on your plat. And the part of the trick is how much we can really do.
But that's, I know through some of your stuff that you've written in here, Judge, that's kind of like the agricultural use on a piece of property. Does a county have an authority to set that, or does that the state level?
Actually, I think the answer is probably neither. It's more on the tax status of it. And here we go back to the appraisal district. To qualify for an agricultural exemption, I believe there's a requirement that it has to be 50 acres. Now, we also have an ag advisory board that advises the appraisal district on requirements. I mean, I've got some personal ideas that if you're really engaged in grazing, for instance, not growing crops, but you need to have water, and you need to have in every pasture, you need cross fencing. But that's just a practical thought.
I know one of the issues that Jed mentioned with TAC in the meeting a couple of weeks ago in Abilene. That was one of the main issues that we talked about in the general session, is subdivisions. And it was concerned to all counties.
Yeah.
You know, that attended it. It's become a problem.
So bringing that up and bringing what he said up, we've got a lawyer to help with wind turbines, you know. Should we look at getting a lawyer? Or, I mean, nothing against Jared over there, but to look at.
He has time.
Not trying to take anything away from you, but I know that in the past, even like the sheriff's office, we hired a special person, you know, to do those certain things. How much would something like that cost?
Well, Gerald's comment was that he can always use help. He won't come down any help. I mean, whether it's turbines or this issue or anything else.
Well, I think Jason's onto something, because a lot of it, I mean, the county's authority is quite limited under the state law, but there's all these other laws out there, environmental laws, flood control ordinances that we are supposed to enforce, that you can use to impose, to bring those requirements into your subdivision ordinance. But we don't know how to do that. So let me see if Jed's come up with a recommendation from TAC. Let me get some pricing. Again, this may be something to do sometime when we have money, but to see if we're talking bigger than a bread box.
Well, I think that's one of the issues too, that people move and buy property in this county because we have very little regulations out here in Mills County.
When I pulled up
Permits.
Hamilton's subdivision, and it's 50 pages, just Hamilton's. And I was like, when I first looked at theirs, I'm like, wait a minute, it's a lot. It's 13, 14 pages,
Theirs is still not in effect yet.
I know, but then San
It's not
Sal's
even
is
in
38
effect.
pages.
They got a deal with them in effect.
How does that work?
Don't ask me. It's the county judge will work. Let me tell you.
I don't know, it's posted.
Okay,
It's posted, but it's never been put into
Clerk's
effect.
office.
I'll
It's
ask
been
him.
put into effect.
Well, I just want to I'll talk to the lawyer that TAC recommended and somebody else if I can find him, so we get a point of reference and see what all's involved, and we continue to talk about this. But it's, as Commissioner Hall mentioned, this is a growing issue for us.
Let me make a couple of points. There's several exceptions to the law that says the county has the authority to regulate subdivision. They all have to do with the fact that there are no roads required to be laid out in the subdivision. If there are no roads laid out in the subdivision, there's about 7 or 8 exceptions that says the county can't do anything to regulate them. Number one, if it's ag use before the subdivision and it's still ag use after the subdivision. Number two, if it's a subdivision relating to relatives, they own it before the subdivision, they're still related after the subdivision. Number three, anything that's over 10 acres, the county cannot, if the lots are all over 10 acres and there's no roads laid out, the county can't regulate it whether it's ag use or not. There's 2 or 3 others. So bear that in mind. In the beginning paragraph of the ones that I submitted said it does not apply to any exceptions. I'll refer back to that statute. Number 2, I filed a subdivision plat a couple of weeks ago, which is the first one I've done in a long time. It's out here just north of town. Filed it in our subdivision book in the clerk's office, and I just looked, the last subdivision was filed in there was 2009. So it's not like we're just being eaten up by these.
Well, but Commissioner Hall mentioned some subdivision in his area,
They right here.
so that means they just didn't file a plat.
Right. Let me keep going. Another point is any subdivision that's within half a mile of the municipality is subject to the jurisdiction of that municipality, not the county. Municipality subdivision regulation, which is one thing they did in Brown County. Brownwood, Early, and Banks have all signed off on the same regulations as the county. So the regulations are the same, whether it's in the city or in the county, which just makes it less complicated for surveyors and developers so they know what to do. So, those are just some points that I want to make sure everybody was clear on. I would hate to see a 50-page subdivision.
That was me too.
Because what's going to happen is people are just going to ignore it. And it's just not going to be enforced. Which is why I'm in favor of a shorter, simpler version that's easy to understand, it's easy to know if somebody's going to buy it or not. So,
Yeah, I did not read the 50-page one.
Okay, I will come back to a future meeting with some
one more thing
information.
before I
Yeah.
This is more of a technical issue, but the subdivision regulations that I submitted, which came from Wayne County, require the subdivider to submit a Mylar map. Mylar is plastic. You can't fold it. And our current filing system over here, you fold it up and put it in volume 132. Most counties have subdivision cabinets, which are slides. You lay these Mylar maps in a slide and you slide it in the cabinet and shut the door, which would involve buying a cabinet for our county clerk's office to use to record the subdivision plats. And in Brown County, when you file a plat, the record, there's a filing fee that you pay, and one of the line items, if you pay on that filing fee, is the sum of money that goes to the clerk's office to pay for these cabinets. So I think it's something that you, it would fund itself unless you don't have more than one filing in 13 years. It might.
Or it would be a large fee.
But anyway, I just wanted to throw that out for you to consider all of
Okay, well, I'm sure the clerk appreciates your lobbying for a new cabinet. Okay, we'll see that one again. Number 9, the reinvestment zone hearings. I've wanted to sort of walk the court through what we're coming up with. Let me get my agenda out for it. I'm not finding it, so I'm going to have to wing it. Last week's Eagle, you saw probably a whole page or more of Mills County advertisements. There were 4 notices that we had to give. You have to give a 7-day published notice prior to the public hearing to establish a reinvestment zone. You have to have a reinvestment zone before you can do a tax abatement. You have to, so there was 1 notice about the reinvestment zones. The reinvestment zones, we're told, had to be described by legal description. So if you read that newspaper, there was pages and pages of, not pages, that's wrong, lines and lines of abstract numbers and surveys. We got more than a few calls, people couldn't figure it out. But I knew that, but that's the requirement. That's why we did it that way. Now, the application, which has been filed on both proposed projects, contains maps. Those applications are now on our website under public information. And so if somebody goes in there and they want to see the map, that's where the maps are. So 7 days after the Eagle publication it might be Wednesday, but just to be safe, I called it Thursday. So Thursday, we have a special meeting to accommodate both public hearings. I separated the hearings because they're different geographic locations, different companies involved as sponsor, different neighborhoods. As opposed to if you just had one hearing, people are going to get confused. It's going to be confusing as to who's talking about which project and which problem. So that's the reason for the separation. Technically, what there'll be, we'll open a commissioner's court and we will recess. We will recess for a public hearing. We'll convene a public hearing at 9:00 on the Bluebonnet Wind Power Project. Now, what we're doing is the public hearing is on establishing a reinvestment zone. There's, in the guidelines and criteria, there's you have to meet certain tests to have a reinvestment zone. It has to be a approved facility. It has to bring economic benefit to the county, and it can't bring, if there's one other thing, I think, public health and safety and morals issues. Believe is what it actually says. So we'll let whoever speak. It'll be our usual COVID stuff. We'll have Zoom and YouTube. Our attorney from Sweetwater, Jeff Allen, will be attending via Zoom. After we close the public hearing, there's no way to tell how long this thing will last. It could go on for a while. It could be like our last one that took 5 or 10 minutes, and that was mostly me. So we're still in recess. So once we close that public hearing, the court continues in recess until we have the Pretty Wind Project public hearing, and that's scheduled because we had to publish the times. So we just picked the time, and it's 10:30. So we'll then have that one. That will end. We'll reconvene Commissioners Court and consider an act on resolutions on the to establish the reinvestment zones. Jeff Allen, our attorney, is drafting those resolutions for us. I should have them shortly, and we'll circulate them in advance. The resolutions would have a map and the legal description attached to it. This, and I'll reiterate at the hearing, is the decision on a reinvestment zone is really tightly focused on, do you meet the criteria in Section 2 of the guidelines? That's the deal. This is not going to be a discussion or anything on the amount of the abatement, the setbacks, the number of turbines. I mean, what's involved is the amount of the investment, the dollar amount of the investment, number of employees, and is it harmful to the county? We have to give notice, and we've given it, registered mail to the other taxing entities that are involved. So it's basically the school district. Although in case of the Pretty project, it's also the Hamilton County School District. So they have the right to attend and object or speak. That is what we're doing Thursday. The 30-day notice is for the abatement. And that, to me, that's the big decision. That's the financial decision. That's where all in the applications, each applicant has put in, their setbacks, what they're going to do, height restrictions. It's all on the website. But those are terms of the abatement for the court to consider, change, or disapprove. That is not a public hearing on how they write the laws, but that is a public meeting. So that's just a regular commissioners court meeting, which is a public meeting. We're doing that at our to meet the 30-day requirement, and it has to be a regularly scheduled court meeting. That puts it, let's see, I've got a calendar here. Our regular scheduled meeting of November 23rd. That's the fourth Monday in November. So that is sort of why it's broken apart the way it is, the reasons behind it, and the components. One's on the outline of the project and designating the zone, and the other is on the terms. I want to talk a little more about the terms, but before I go any further, that's a lot of information. Are there any questions from the court on how we're attacking this? On the abatement, I mean, there's all sorts of things to consider, but to me, the big issue is the concept of an abatement versus what's called colloquially a pilot, which is short for payment in lieu of taxes. So in effect, in a pilot program, you abate 100% of the taxes for 10 years, hypothetically 10 years. So, okay, no taxes are owed, but in return for that 100% designation, you're going to pay me cash of so much a year. That's the pilot payments. That is strongly preferable. I mean, to me, because other counties would tell you, let you budget better. What I'd tell you is, under this new truth in taxation law, where you have to have voter approval if you increase your tax rate, the depreciation curve on these wind farms kills you, because you got a big amount of money the first year and then it starts coming down. So your tax revenue's coming down. So you have to raise your rates to keep the same amount of tax revenue coming in at some point. And if you hit that 3.5% level, or 3.5% adjusted for the de minimis amount, you start having to call an election. The pilot payments number one, they're fixed, so they don't go down. And number two, they're not considered taxes. So they don't go into that calculation. So it lets you avoid all of the tax rate voter election risk by having the payments come in basically as a fee rather than taxes. That's just a commercial I wanted to put out there for your consideration, but that's to me, a compelling business reason to lean into, so to speak, a pilot calculation versus a pure abatement.
Under your two scenarios that you told the court, under the pilot program, what takes place in 10 years?
It's 100% on the tax rolls at whatever the market value is at that time.
Because
Yeah, what happens is you've 100% abated it for 10 years. That abatement's done. Bang, it's on the tax rolls. Well, that's the plan for Thursday. Thank you for the. Yeah. Any other discussion on that? Commissioners' requests and reports. Commissioner Wright?
We've been busy with road work. I found that they've opened a new pit, a quarry that I was informed about. Robert had told me about it. He'd seen it, and he and I made a trip up. It's the other side of Sin Saddle, and I'm gonna try to buy some material from them. And it's awful good material delivered to my precinct barn, 14 to 16 tons per load. They're going to do for $130, and I can't find that anywhere else. That's awful cheap. And like I say, they guarantee 14 to 16 tons per load delivered to my yard, and it's about 32 miles one way. I took the brush cutter to Jed on Thursday the 22nd. He has it. I picked up the bands for the brush cutter. The rock crusher. I picked those up from Kirby's, and I delivered those to Robert. He has those. And also I met town hall meeting Friday. Mr. Conway was here, and he's leaving after 16 years of service, and he's represented our area real well. And I had a special interest in it too, meeting with him. That's who my grandson is interning with right now in Washington, D.C. This is his office. And so, but anyway, he was looking forward to spending more time with his family and his grandkids. But that's all I have.
Commissioner Gary?
I was at Conway's deal with Mike. We're almost through the work we're doing on 332. We like just a little bit to have a whole mile rebuilt. And that's what we've been doing. And that's not all I've done.
We've been hauling base on 520 and 517 running the rock crusher. This week, we're gonna try to get them plates put on it. So far, I haven't found anybody that wants to weld on them wheels. As far as it'll weaken it. Nope. Don't want to touch it.
And that's one thing Kirby did say about welding
Yep.
home. Make sure that you disconnect those batteries on, because you're gonna tear up all the electric.
I asked Sides when they could do it, and they said they preferred not to do it. Sam Bell will do it, but he's way behind, and when he's gonna be able to do it. But we've been running rock crusher. So I'll find somebody that's a certified, it needs to be a certified welder. So we're at them predicaments right now. And
What's your
then
definition of certified welder?
I don't, anybody welding on
Well,
that.
I'm saying you get your certification, you just go into a junior college or whatever, you get your certification from going to high school.
Well, get
So
somebody
your
from Dover High
definition of
School welding.
certified is kind of broad.
But anyway, and then Thursday night, late Thursday night, I had a call from an individual out west of town, said there were some trees on the road, that he had tried to notify me, which I have not been notified, that they were down all day Thursday. And part of the road was blocked. It was passable and been passable forever. But we went out and removed them Friday and got them off the road. And that's it.
Commissioner Williams?
Been hauling some material from Porter's, County Road 508, and also taking some to the yard. Did some tree trimming and shredding work. Thanks for, Robert letting me get the shredder for a few days. And we had done the repairs on the where that was.
Did we get the loader? Was it a seal or?
Seal. So, replace the seal. Maintenance work, that was part of that, and also done some road work and some right-of-way work way out west. So that's it.
Okay, judge's report. So quick COVID update with, obviously, I don't know what's come in the last hour or two, but we were sitting on 18 active cases in Mills County and 100 recoveries and 1 death. We have a deadline coming up in November for the filing the project list on the transportation infrastructure grant from TxDOT. Y'all have all turned in the revised project list, and Commissioner Williams working to get that turned into TxDOT. So we'll be done on that. And I wanted to mention, or the clerk may want to speak to this, that we've had just over 40% of the registered voters of Mills County have early voted through last Friday. And we have another week to go. That's this week. And there were lines out the front up until early last week. It finally subsided. So if you haven't voted, it might be a good time to do it. I expect maybe we get down to the last day or two of early voting this week. There may be lines again.
May not be very close to cold.
Yeah, it might be a good time to go vote.
Be a good time to go vote.
So.
Okay, that's all I've got. Is there a motion to adjourn?
So moved.
Motion, and is there a second?
I'll see.
We have a motion and a second. All in favor, say aye.
Aye.
Meeting adjourned.